You may start, ma'am.
Okay. Today we are going to begin with the concept of Negotiable Instruments Act, and we precede the discussion of Negotiable Instrument Act is usually preceded by the
Start, ma'am.
discussions. Uh, I have started. Hello. Today we are going to begin with the concept of Negotiable Instruments Act. Mr.
And
Rehan, we precede the discussion of Negotiable Instrument Act is usually preceded by the discussions. Hello. I have started. Hello. Today we are going to begin the concept. We begin with our discussions on garnishee order, which is a part of the banker-customer relationship. Banker-customer relationship is basically one of the most fundamental relationships in the banking sector of the country, whereas which deals with the commercial transactions in the economy as such. However, when we are talking about the banker-customer relationship, the exception to one of the obligations of a banker happens to be that of the garnishee order. Because a banker's primary obligation is to honor the instructions given by the customer, whereas the particular instruction can only be overridden by a court's order, which is in the form of a garnishee order. And garnishee order has been spoken about under the Civil Procedure Code as such. Now, the reason why it precedes is because most of the transactions that we are going to deal with in Negotiable Instruments Act deals with the rights and obligations of a banker and how a banker can save itself from any sort of liabilities that may emanate out of negotiable instruments. Negotiable instruments are those instruments that enable the transaction, commercial transactions or transactions in money from one person to the next. Now, whenever we are talking about negotiable instruments, we are talking about those kinds of instruments which are that of promissory note, bills of exchange, or check. Now, the fact is that every single time a banker is involved, mostly in the form of in the transactions that involve the form of negotiable instrument, that is a check, a particular banker incurs certain liabilities and has certain obligations to fulfill. So those sort of obligations, those sort of liabilities that a banker would have in the course of transaction, if he does not do a payment in due course, in such cases, that will be a ground, a very valid or a legitimate ground for the banker to incur the kind of what do you say, liabilities. But say supposing if there's a court order then clearly the banker is absolved of all its liabilities because the court order usually would override that of the customer. And which is why even if the banker refuses to honor these instruments, these negotiable instruments, the banker will not incur any liabilities as a consequence. But there's a whole procedure to it. So this is not devoid of procedure. The whole procedure mentions that there has to be a legitimate notice of a certain time period, etc., and pursuant to which basically that there would be uh, a transaction. Now
Ma'am,
let's look
is
in let's look
sorry,
into
ma'am.
what negotiable instruments are.
Hello.
How do you understand what negotiable instruments are, and how is the concept of negotiability different from transferability? Every single time that we are talking about negotiability, we have to picture a particular fact situation whereby we think about a particular book, or say a particular laptop or a pen or whatever that belongs to you. An article that you want to give it away, you want to sell, or you want to uh, change the ownership of, basically. So if I want to give you a book, if I want to sell you the book, I will be giving you the rights of that particular book. The rights of that particular book will be uh, upon uh, when you get the rights of the book, basically, you are supposed to you you basically get the best title to that particular book. You basically would get the right to sell it or right to rent it, etc., etc. So you, upon getting the absolute good title to that particular book, you you are basically in a position of uh, getting all the rights to that book. You can transfer the title that you have received. However, if you were to find that book somewhere, and say supposing if you took the possession of the book and you wanted to sell it off, would you do that? Today, when you want to sell, say, a laptop, maybe, or say a vehicle for that matter, in such cases there will be a certain proof that would be required from you in order to prove that you are actually a good title holder. In transferable goods, you cannot transfer a better title than what you own. So this is something, a title to the good is something, is a proof or is an acknowledgement of the rights that you enjoy with respect to that particular good. So every single time we are talking about a title to the good, the idea is that you will have to you will have to see what sort of title is being bestowed upon you. So if it's a transferable instrument, you can't transfer a better title than what you own. However, this is where the distinction with the negotiable instruments come, because in the case of negotiability, you can in fact transfer a better title than what you own. So even regardless of any kind of defect that there may be in the title of the good that you have been given or negotiated with respect to a particular instrument, you still can transfer a better title than what you hold. Supposing you get a check um, as a consequence of, say, a blank check, which is lying on the road, a blank open check which is lying on the streets. You find that check which has been duly signed by the person who is the drawer, who's the maker, and then you write a certain amount, you write your name on that particular check, and you go and get it encashed. Now, the moment you take the check to the banker is not going to do a due diligence, or they are not going to go into fact finding or inquiry proceedings, etc., to find out if you are the person who has been named, who has been uh, bestowed upon or given the amount of money which is written on the check. So long as your name is there on the check, the only what do you say verification that is required to be done is to find out whether your identity matches with the name which is mentioned on the check. but no more than that. Or if there are any sort of material alterations, supposing if the name has been overwritten or the check is mutilated, or say the banker has reasons to believe that the person who has made the check is now dead or insolvent, or any of that sort, basically. So reasonable inquiries could be made, but in the course of the fact that if it was a normal course of business and there was a blank check that was lying, and maybe you were a habitual customer of your bank, or maybe if you wanted to cross the check and put it to your bank for encashment, etc., the idea is that the banker would, without incurring any sort of significant liability, any sort of liabilities for that matter, could now get this entire amount of money deposited and cashed in your account, or give you over the counter, whichever is sought by the customer based on the instrument's instruction. So the whole idea is that whenever we are talking about negotiability, you basically are supposed to get, if you get a check, say out of a transaction that involves gambling, or maybe you stole a check, the fact that you are not the owner, or you are not the person entitled to the money that is on the check, makes no difference. At least with respect to to Negotiable Instruments Act, it actually makes no difference. So when we are talking about negotiable instruments as such, what exactly are we talking about with respect to negotiability? What are we talking about with respect to how negotiable instruments function, and what makes a negotiable instrument negotiable and its act actually makes no difference. So when we are talking about, and what exactly makes this entire concept of negotiable instruments different from transferable instruments.
Madam, you are not audible. Hello, ma'am. Ma'am, you are not audible. ম্যাডাম আপনার স্পিকারটা অন করুন। ম্যাডাম প্লিজ স্পিকার অন। হ্যালো, হ্যালো, অন্বেষা ম্যাম।
There used to be certain businesses, say mercantile businesses, etc. They usually talk about there are many kinds of negotiable instruments. If you look at section 13, the very first subsection has been spoken about in the sense that it's an exhaustive list of negotiable instrument which has been spoken about with respect to how many kinds of negotiable instruments are there. We are not involving the concepts of bills of lading. We're not talking about any other sort of instruments which may be given the status of a negotiable instrument. Because if those were given the status of a negotiable instrument, they'd have to be dealt with under a completely separate act and not Negotiable Instruments Act as such, the 1881, because they only talk about these three negotiable instruments, which are promissory notes, bills of exchange, and check. So imagine there was a bill of lading. So there's a shipment which possibly has to come from uh, Singapore to India to Calcutta. So there's a person who loads on the goods in on the dockyard in Singapore, and there's a person who offloads the goods in one of these dockyards in India. So the person based in Singapore, whenever he's unloading on the the goods onto the ship on the dock of Singapore, the person will have to carry, will get a receipt basically that certain this is the specification of the goods, the quality of goods, the number of goods, the volume of goods, etc. And this will be delivered on Calcutta's dockyard to a certain person, to whoever basically bears this particular instrument or the name of the person whoever is mentioned, and they can show it to the ship owner, and then the ship owner can very well give it away to this person. So this would be in the form of a bill of lading. Now, if this is a bill of lading, how exactly do we talk about what exactly is a bill of exchange, promissory note, or a check? So bills of lading may have its own rules to follow. Bills of lading may have the kind of rule which is possibly mentioned in the mercantile laws, etc. But with respect to Negotiable Instruments Act, bills of lading are not to be considered as a valid negotiable instrument. Moving forward with respect to the three negotiable instruments that we have, and there was one another which has become illegal as a tender, as a negotiable instrument, which was the hundi. So say supposing there's a man who's based in Bangladesh and the currency is very different from that of the Indian currency. The fact that this man from Bangladesh has sent one of his children to study, to have education in the country of India. Now, if he has to send money to this son of his who's based in India, how is he going to do? So he has to first go to the person who claims to be the money lender in his village. That money lender might have some agents who are based in India, and thereafter this particular money would be given to this man. So it's a very long, tedious procedure, basically. But this was only to ensure that there would be a security as to the payment. That's because this security was required since the law and order situation was really poor at that point of time between the nations, as well as the fact that as well as the fact that the entire concept of receipt give and take was something that receipt was something which was called a hundi, and that was not a good enough acknowledgement because it was not done through very proper channels, or was possibly prone to a lot of law and order issues, and was possibly prone to a lot of offenses or crimes that could have happened. So which is why many reasons why hundis were removed as a legal tender, but hundis as such served much the purpose in the same way. And this entire concept of how the entire, the gamut of promissory note has come about. It involves the inclusion of banks. Hundis was primarily being done without the involvement of banks and outside the purview of banks, which is why it was made to look like it was some sort of a hawala transaction, if on today's date, if you were to think about it that way. Now, when we are talking about what exactly are these three instruments, promissory note, bills of exchange, etc., we see what section 14 says. Negotiation means when a promissory note, bill of exchange, or check is transferred to any person so as to constitute that person the holder thereof, and the instrument is said to be negotiated. The whole concept of negotiation as such is basically based on the fact that we are talking about certain instruments in which the property can transfer, certain instruments in which the property may not transfer from one person to the other, and what sort of title is being transferred from one person to the next. That's one of the most basic uh, understandings of negotiable instruments. So let's talk about the definition first. It says you constitute that other person as a holder. Who's a holder? Holder has also been defined under this Negotiable Instrument Act. It basically means that whoever is a person who is entitled to all the rights in that property, whether it be presentment of that particular instrument for payment, or whether it be to ask for a duplicate copy of that instrument, or whether it be for the purposes of filling up the details of that instrument if it is an incomplete instrument. Could be for various reasons. A person who is entitled in his own name to that particular instrument, that person would be considered as the holder. Now, let's talk let's talk about what exactly are these instruments. The first is a promissory note. Now look at section 4. A promissory note is an instrument in writing, not being a banknote or a currency note, containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So this concept, Mane, the fact is that when we are talking about what exactly is a promissory note is where you have two parties, essentially. These two parties, one is the maker, one is the payee. This particular arrangement, where there's a maker and then there's a payee, this particular arrangement is something that makes a person a creditor and the other a debtor. So the debtor is supposed to pay that amount which he has mentioned on the promissory note to the payee, to the creditor. And this creditor will actually be the holder of that promissory note because he has been so named, and the promise to pay the amount of money has been made by the debtor to him. Now, we are not discussing about the fact as to how a bank note or a currency note is not any different from promissory note. So every single time that you talk about a currency note, say a 500 rupees or a 100 rupees note, which you have received, that particular note will not have anybody's name on it. So that particular note, the currency note, basically, we use the terms banknotes and currency notes interchangeably because in India, there's just one sovereign authority who actually issues the currency in consultation with the government, which is the RBI. So we don't have bank specific notes or bank specific legal tenders, which would be competing for value amongst each other, etc. So for one particular country, we just have one particular apex bank which decides and pumps in money into the economy. But whenever we are talking about who the holder is, the person is the creditor who is supposed to get the money from the debtor. He's supposed to get the sum of money which has been written or promised. And the fact that we don't consider currency notes as promissory notes, that's because you can't have a currency note which is addressed to someone. So the fact that currency notes are not promissory notes, that has to be absolutely clear from the very outset. So if you look at your uh, how promissory notes are dealt with, this is basically the reason how a promissory note will be different from a currency note, because promissory notes could be made to order. The next is with respect to with respect to your checks. Now, one of the basic reasons why check is so different from uh, a check is very different from a promissory note, or say a bill of exchange would be very different from a promissory note. We are going to talk about what checks are in the first place. But before that, we talk about bills of exchanges. A bill of exchange is basically look at section 5, is an instrument in writing containing an unconditional order which has been signed by the maker directing a certain person to pay a certain sum of money only to, or to be uh, or to the order of a certain person, or to the bearer of this instrument. Now, bill of exchange and check are very similar in certain aspects. The aspects being the fact that you need to have three parties. So, in a bill of exchange or a credit, what do you say, arrangement with respect to what do you say, with respect to decision, the idea is that three parties are involved. The aspect being the fact that need to have three parties. Bills of exchanges will have three parties. You have this as a three party, the check has a three-party mechanism, and many more. Now, what exactly is this three-party mechanism? Every single time that you go to the US, every single time that you go and say, it doesn't have to be necessarily always in a different jurisdiction. Supposing if you have an instrument, right, which you want to get paid. Now, bills of exchange and check are basically in the nature of an instruction. So, instruction means that I will have a certain amount of uh, direction that I want to give to another person, who will then take my directions and then go and fulfill that particular work accordingly. So when we are talking about the what do you say, direction. Bills of exchange presume three parties. So these three parties are those where one of them is making the bill and the other one is the one who's getting paid on the bill. But the third party is someone who is being directed by the maker of the bill to pay to the party who owes, who is supposed to get the money. So the whole concept is that this is again a lock for what do you say? This could be again one of the examples for uh, that uh, bill of exchange. The third person I said could be anybody who is dealing only under the instructions of the maker. With respect to uh, your checks have this one peculiarity within it, that checks will not what do you say, um, will not be any different from a bill of exchange because they also have three parties in it. So what are the three parties that a check has? A check will have one of the parties as a banker. So whenever there are two parties in a particular transaction and the third party who has to be instructed is a banker, then such an instrument, a negotiable instrument, is considered to be a check. But bill of exchange can be, the instruction can be given out in various formats. But in a check, there's no exchange of one particular format that deals with it. So if you have, supposing if you have uh, a very good, what do you say, uh, uh, relation with the banker, even despite the fact that you're a customer, the fact is that the banker ideally will not want to close down the accounts, etc., and would possibly uh, direct you to make an instruction to the banker in a proper format. So, which basically means that if we are talking about one concept, if you are talking about one particular check, the check is something which needs to be uh, paid, and the banker is the one who's supposed to get the direction in order to pay. So, what do the banks do? The banks maintain the operating accounts like savings, current, overdraft accounts operated by checks drawn by account holders on their banks, etc. The next is with respect to banker is a paying banker or a collecting banker while dealing with checks. So if it is over the counter checks, they can be done through one particular banker. But if it is between September as well as uh, here, then in that case, it would have been a problem. So the entire concept of banks maintain operating grounds like savings, bank, savings account or current account or overdraft facilities or say something that is operated as an ancillary service by the bank. So there are multiple reasons with respect to how the dealings take place. So what exactly are the legal aspects of check? Check is a bill of exchange. Second, payable on demand. Third, drawn on a specified banker. It's a payable on demand provided it's not a post-dated check. Or the fact that you took a prepaid, what do you say, transportation. So for all of these reasons, there's a check which unless it's in the thick of things. The idea is that we don't consider uh, any other tenor of instrument other than the format of a check to be a valid instrument. So a checkbook is usually issued from the bank of your account. So that particular amount is something which you need to uh, write down. So what are the legal aspects of check? Check is a bill of exchange which is payable on demand, drawn by one particular specific banker, which is true. However, checks cannot be payable on demand. That's one thing that you'll have to keep in mind. Now, there are four kinds of checks. What are they? One of them is an open check. The second one is a bearer's check. The third one is an order check. And these, fourth one is a cross check. And these particular checks are those where you have to so when we are talking about the kinds of checks, what are the kinds of checks? The first one is a bearer's check. So when we are talking about open checks, open checks are those checks which are usually the ones where an account pay instruction is not written. So every single time that you find a check somewhere lying around, or say if you have been legitimately given the check by someone, in such cases, that check will be an open check if there is no security which is attached to it to make it more vulnerable. And what is the security that they seek? The security is that of the fact that the check has uh, the number of the kind of what do you say, the tenor, the format. So every single time that you have a check from a checkbook, you'll see that there are 16 digits numbers which are mentioned in the back in the foreground. What exactly are these 16 digits? So the first four, I may be jumbling it up. Maybe the first floor is Rice Newton. The entire concept of a check basically would be with respect to what is the tenor. So the first four digit of that particular 16 digit code, which is written on the check, is a branch name, is the branch code, or the city code, or the bank code. And the last five digits would be your check number. So there are various ways of ascertaining which particular check has been issued from which particular bank, which branch, which area, city, locality, all of these. So if you have that particular check, only then will you be able to make a certain withdrawal. Now, the entire check, whenever it's sent for encashment from, say, my banker to your banker, usually an open check, it doesn't happen from banker to banker. It happens from one banker and one individual customer. So in such cases, say supposing there is a particular banker which has been uh, which has received your check. Now, that particular check which the banker has received, they will have to forward it to another banker who's supposed to make the payment, because that banker happens to be the banker of the maker of the check. Once this particular check has been received by the banker, that banker will now check for the veracity of the instrument. what are the things that are mentioned on the check, whether the check is complete in all respects, whether if it's forged, what exactly is it that the check is falling short of, etc. Once the ascertainment has been done, clearly the check is then cleared, and then the money is then given, and the whole check is the money is then given to the collecting banker, and the collecting banker then encashes your bank account with that amount of money. So there is a whole way, there's a sequence of the whole thing working. If it's an account paycheck or if it's an open check where there is just one banker who's involved who's supposed to pay you over the counter. Now, the other kind of check is a bearer's check. A bearer check is a check which has been uh, written in such a way which doesn't have any name of the holder on it. So when we are talking about a bearer's check, we are essentially talking about a check which, by virtue of possession, will become yours. And if you go and get money out of it, nobody is going to say anything uh, for that matter. Nobody's going to do any sort of due diligence. Nobody's going to check as to whether or not you were in fact the bona fide holder, etc., etc. So no person is going to ask you on that check so long as the check is a bearer's check. But obviously, the banker will then ask you to complete the instrument. If it's you know, what do you say? Uh, a check which is open will be extremely vulnerable to the fact that whoever can encash, anyone can encash the particular uh, check. So that's a bearer's check. When we are talking about order checks as opposed to a bearer check, an order check is where we are talking about checks that are uh, made to somebody's name. So if I write pay to Anvesha, so it means that it has been made to me. So if any Tom, Dick, and Harry, if he possesses the check because maybe I've lost the check or somebody's stolen the check from me, and just because they have the possession of the check, they can't claim to be the holder because my name is clearly written on the holder's space. So they may constitute themselves as holders if negotiability has really not been stopped, but or restricted, which usually happens under Section 130, etc. However, the fact that if you are in what do you say, a situation whereby you have to get the check encashed or you have to pay to only one person and you want to ensure that the person who has been named is the one who gets the benefits, that person's name will have to be written and that will be an order check. The next is with respect to your cross checks. Crossing makes an instrument extremely credible or less prone to vulnerability. So, whenever we are talking about crossing of checks, we are usually talking about the fact that you are ensuring that the check does not is not received by anybody who's unscrupulous or anybody who's not supposed to be entitled to this particular check, and so on and so forth. So much so that you can even uh, you can even keep those checks, cross checks, to be in a way that the crossing entails only the what do you say? The crossing only entails the name of the bank which can encash the check. So not all the banks. So if I am a particular uh if I have, say, bank accounts across 5 different banks, and say supposing in such cases there is one particular bank which needs to which should be getting the rights of encashing that particular check. So in such cases, that bank bank will be mentioned in the special crossing. Otherwise, there would be a general crossing whereby things can be written in a different way, whereby just two transverse lines are good enough for you to maintain as to the fact that you want the payment to be done in an account pay. So, whenever we are talking about crossing, there are many ways of crossing. The many ways of crossing, one of the most common ways of crossing is to just put two transverse lines across, and that particular transverse line is something which has to be put uh, across the face of the check, or at the back of the check, or at the in a piece of paper which is on a stamp paper. So these sort of crossing, there can be one another kind of crossing whereby you are talking about a not negotiable crossing, whereby you're trying to make the entire thing very what do you say? You're trying to make the entire instrument extremely secure. And what is the security that you are doing? The security is where you're trying to put that it is not given the status of negotiable instrument, in the sense that even if it is negotiated in the first go, the from the second endorsement onwards, it is not done, because in such cases, the moment you restrict the negotiability, then in such cases no other negotiation can take place, and the entire instrument would become very secure. So even if it is lost, nobody can endorse it in their name. So the person whose name is mentioned as a holder will be the only person entitled to get that particular uh, to get that particular uh, money's benefit on that particular check. So basically, when we are talking about the concept of uh, crossing, let's look into section 123 to section 131. Second. One 123, which is a chapter based on crossed checks crossed generally, till 131. This is for demand drafts. You're only concerned until 131, non-liability of banker receiving payment of check. So these are the sections that deal with crossing. So what exactly is crossing? Let's deal with this particular section in detail. Yeah. Section 123 talks about checks that are crossed generally. So only two transverse lines across a particular instrument. I can even show it to you if it is if it can be done. 1 second. So basically, when we are talking about if this is visible, this is where two transverse lines have to be. So this is to, this says pay to. This is where you write the checks as to. This is the amount in figures. This is the amount in words. Yeah. This one. This is a signature. This is a sign, or here is the account number of the person who's making the signature, who's signing basically the maker. And this is where you write either you write account pay or you don't write anything at all. So this is where you write, this is where the crossing of the check happens. So it can be either at the front or it can be either at the back of the check or it can be on a separate piece of paper which is annexed to it. Depends on how you want to show that the check has been crossed. Once it's account payee, that basically means that it can only be paid to the account of the person and not over the counter. If it's mentioned account payee to SBI only, so in such cases, your SBI bank is the only bank which can act as a collecting banker for your check. Okay. And this is amount. So when we are talking about general crossing, this is what it says, and company, you just write account payee. The second is cross specially, where you also put in the name of the banker, which I said about SBI, SBI and company, etc. The third is not negotiable crossing, 130, which basically says that if you write not negotiable on it, it means that it will not have any sort of negotiability characteristics associated with it once it has been given to one person. So, how is negotiation carried out within a negotiable instrument? This is one of the most important questions. So, transfer, you know, if I give the book to you or if I have a document which I give to you, that's the transfer. But with respect to negotiation, it's either when I have given you that particular instrument, but delivery is one of the most important things. Without delivery, you can't transfer the instrument. And second is whether it is constructive delivery, actual physical delivery, etc. Delivery has to be there. And second thing is that of endorsements. So if it's a bearer's instrument, it doesn't require any endorsements as such, so it can only be delivered. However, if it's an ordered instrument, it has to be endorsed and delivered. But say supposing if I endorse something and I deliver, and if that endorsement or if say supposing I endorse something and I keep it in my drawer, if I keep it in my cupboard locked aside and I don't deliver, so if somebody steals it from my cupboard, or say if after my death somebody has stolen it and gone and given it to somebody else, the fact that delivery was not done, or the fact that I never intended to deliver, or even after endorsements or with or without endorsements, the fact is that this particular instrument will no longer be considered to be an instrument which can be what do you say, encashed by the banker. So whenever we are talking about who can or who cannot encash, or what exactly is the role of the banker with respect to this, not negotiable crossings are basically where you have no endorsements anymore that is associated. So the particular instrument could have been, say, endorsed 10 times, but maybe the 11th time it has been mentioned and not negotiable. Even that can happen. Crossing after issue. This basically means that where a check is uncrossed, the person who's a holder, he can cross it. So at any given point of time, whoever is a holder, even if the crossing has not been done by the maker's hands, by the person who's drawing upon the check from his own hands, still it can actually be done by any intervening party who is a part of the entire concept of the entire process of endorsements before the check is encashed finally, presented for encashment finally. So whether if it's crossed generally, the holder may cross it specially. If if there's no crossing, the holder can cross it. If it's general crossing, which has been done already, you can cross it specially. If it's crossed specially or generally, you can even add the words not negotiable. So the fact is, the entire concept is that of what the rights of a holder are. So as a holder, you can actually cross and you can make the instructions on the piece of paper on that particular check, which has to be followed by the banker of the drawer of the maker. Even though you're the holder, you can still make instructions to the person's banker, to the person whose account will be deducted, that person's banker. Where a check is crossed specially, the banker to whom it is crossed may again cross it specially to another banker, his agent for collection. Now, sometimes it may so happen that you may not have uh, the exact amount of what do you say, the bank branches that there may be in a locality. So in such cases, if it has been crossed specially, then the particular banker is supposed to encash that particular check. But if that banker's branch is not available in a particular locality, then they can appoint an agent bank who can do the same. And that can be endorsed by this particular banker. So when we are talking about special crossing, general crossing, let's deal with section 126 after a 10-minute break. Okay, let's resume. So the next section that we were supposed to talk about was section 126 onwards, which talks about which talks about payment of checks cross generally, payment of check cross specially, payment of checks cross specially more than once. Now, whenever it has been done, especially more than once to two different bankers, then clearly it says that the banker on whom it is drawn shall refuse payment thereof. The idea is that special crossing can only be done to one bank, not to two banks together. So in such cases, if there are two banks involved, then the bank can very well refuse the payment. Either you generally cross it so that both the banks can have access, so long that it's an account pay. But if anything else is there, then this has to be done accordingly. Payment in due course of cross check. Payment in due course of cross check would be with respect to where the banker on whom a cross check is drawn has paid the same in due course. The banker paying the check and in such check has come to the hands of the paid, draw thereof shall respectively be entitled to the same rights and be placed in the same position in all respects as they would respectively be entitled to and placed in if the amount of the check had been paid to and received by the true owner thereof. Payment in due course of cross check. Every single time that you pay a particular check in due course, as a banker, you are absolved of all your liabilities and obligations. So payment in due course is something that you have to prove every single time that a banker's liability emanates. You as a banker will have to prove that the payment has been done in due course. What is the meaning of payment in due course? The fact that you have paid on an instrument, the fact that you have paid to the person who is mentioned on the instrument, the fact that you have paid to the correct person, the fact that you have checked if there was any sort of mutilations on the check or overwriting on the check or forged signature of the maker of the check. No matter what the amount may be, the idea is that the amount of money has to be accounted for and the money has to be whatever, even 1 rupee, if it is being taken out from your account, the idea is on what basis. Has there been any instruction to that effect? So that honoring of instruction would only make the payment a legitimate payment, and therefore we talk about it being a payment in due course. Now, payment in due course is something that you have to prove as a banker that this is where the entire payment in due course has happened, and which is why the banker is not liable. Out of due course, the banker would definitely be liable if the money has not been given to the true owner of the check. Now, the fact is that there's only a limit of due diligence that as a banker you can do. What is the limit of the due diligence that you can actually do? If there is one particular amount of work that needs to be done, and say supposing if there is the case of the fact that how the what do you say? How the uh, payment is to be done with respect to the kind of instructions mentioned. If you have done anything outside of it, then in such cases, it would be considered as a payment which is not done in due course, and a banker would then be liable for all the consequences if there has been any reduction of money, then in that case, the reimbursement of that amount of money has to be done by the banker, so on and so forth. Now, 131 talks about non-liability of a banker. A banker who has in good faith and without negligence received payment for a customer of a check, crossed generally or specially to himself, shall not, in case the title of the check proves defective, incur any liability to the true owner of the check by reason only of having received such payment. Good faith and due care, which says that you should not have had any negligence on your part. So, in such cases, if you can prove as a banker that you have acted in good faith and without any negligence, you have taken all the necessary precautions, in such case, you will be absolved of all your obligations. But so long as you can't prove it, your obligations as a banker would remain and eventually your liabilities would come as a consequence. Second. This I will share now. So we are pretty much done with respect to crossing of checks. See, as a thumb rule, we should always understand that a check is not the absolvement of debts. Encashment, yes, but not a check. A check is merely a negotiable instrument. If today, say, supposing if I was staying in a rented apartment and the landlord told me that on the 31st or 30th of November, you have to pay me the rent for the month of December, because if you don't, then I'll consider the entire contract to have been terminated. On the 30th of November, I give my landlord a check and I say, here, now extend my contract. The problem is that your contract may just not be extended and the landlord may just kick you out. And that is because the check that you have given, it is subject to its clearance, its clearing, and it is subject to encashment. So if you don't get the, if you can't get the, if the check never gets encashed, say supposing, then that will be a big problem for the landlord. And clearly the debt would be outstanding. So the landlord needed the rent, but a check was only a promise to pay, but not the payment exactly. Because the encashment, if at all it happens, will come only after a certain period of time. So we have looked into what are checks which are crossed generally. We have looked into what are checks that have been crossed specially. We have spoken about section 130, which talks about not negotiable crossings. So what are the features of a check? Instruments must be in writing, which talks about the tenor. So you can't have something which is oral or done verbally. Clearly, it has to be mentioned, and it has to be mentioned in a format. And the format is something that the banks would give you. So, in the checkbook that the bank has given you, only on those checkbook are you supposed to make those instructions and nowhere else. Not even on a piece of paper, because that will not be honored and the bank can very well refuse it. The next is with respect to unconditional order or promise. So every single, what do you say? Every single check, whenever you're writing a check, you can't have conditions laden onto it. A banker is not supposed to see to it that the conditions laden onto the instructions have been fulfilled or not. It is your lookout. The banker is only going to pay upon your instruction. So if you say that upon the death of a certain celebrity, would you be paying rupees 100 to this person? that sort of a check is not a valid check, and that can very well be dishonored because the banker is not supposed to be in a position to check the fulfillment of the conditions under any circumstance, be it any sort of conditions. The next we talk about check versus bills of exchange, which talk about the fact that in a bill of exchange, the third party could be anybody else other than a banker, whereas in a check, it is always necessarily going to be a banker. It can be something which is payable to order or to bearer, which is under section 13. The next is with respect to it must be to certain persons. The next is with respect to the certainty of the amount. So it can't be, say, $50. How would you know what is the equivalent of $50 as on today at such and such time when the check has been presented for encashment? So all of these things, the amount has to be certain, the person to whom you're making the payment has to be certain, can't be either or. The drawer, the person who's making the check, he needs to be a person with a genuine signature. With respect to delivery, it's very essential. Without delivery, you can't have negotiability extended. And finally, we come to the concepts of Section 8 and Section 9. What do these sections talk about? Section 8 talks about who a holder is, whereas Section 9 talks about what a holder in due course is. Every single time that we are talking about endorsements, endorsements are basically whereby you are trying to mention that a certain person will now get the rights, the ownership rights of a certain instrument. So that particular instrument, whatever it may be it a bill of exchange, be it a check, be it a promissory note for that matter, how are you going to make the person receiving that instrument a holder? You bequeath absolute rights in that particular instrument, so much so that the person can now uh, claim for that particular amount of money in his own name. And the fact that with respect to how uh, uh, how the particular amount of money has to be given, that would be written over there. The next is with respect to a holder in due course. So every intervening person, every intervening party of that particular endorsement would be considered as a holder in due course. So this holder in due course concept actually comes from the whole concepts of endorsement and the fact that it would constitute you as a holder the moment you are entitled to, you are the one who's presenting the check for payment to the banker. The next is with respect to rights of a holder. What are the rights of a holder? If you are the person who's presenting the check, you can complete the endorsement. So if there is an endorsement, it amounts to being a bearer's instrument, like a blank open, not an open, but a blank instrument which doesn't have the name of the person who is entitled to claim for the money. So being the holder, you can write your name or whosoever's name, because you are the bona fide holder, you are the person who's last holding and entitled to present that check for encashment. The next is he can negotiate a check to a third person if such negotiation is not prohibited by direction given in the check. Clearly, if there is no not negotiable crossing under section 130, that can be given as that can be negotiated further by means of endorsements to another person. He can claim the payment on the instrument and can sue in his own name. So no matter, it doesn't matter how many, which, it doesn't matter how much, what is the number of his holding of that particular instrument. So maybe the instrument was made to A endorsed it to B endorsed it to C endorsed it to D endorsed it to E for that matter, and E has given it to you. So you may be the sixth person or the seventh person or whoever basically to hold that instrument. But the fact is that this instrument that you are now holding, the because you are the last holder, you have not endorsed it any further. If there is no endorsement, if it is done in blank, if your name is not mentioned, you can mention your name as a holder because that's allowed. And secondly, the fact that the payment can be claimed on the instrument and can sue, and the person can sue in his own name. There's a duplicate copy of a lost check that can be obtained by a holder. Clearly, because you are the one who has received the check for a certain debt that a person owed to you. So maybe you've sold something or you've done some sort of service for a certain person for which a check has been given to you. And that check is something that you have received through lawful means. So if that check is mutilated or is lost for some reason, you can very well ask for a duplicate copy of that check from the person who's made the check. The next is with respect to privileges of a holder in due course. A holder in due course, the very first is that he possesses a title which is better than the previous owner and is also free from all defects. So if I have received a particular check because I was playing a match of gambling, and that gambling or say I've murdered someone and as a consideration I've received that check. So in such cases, all of these checks that I'm getting, those checks are considered to be your what do you say, uh, against the law. And if it is against the law, these defects that can arise through for that instrument which you are now holding, since you have received it for full value because you have performed a very bona fide service for which you have received that amount of money, maybe not a fresh check, but it's a check which has been endorsed to you, that says that the holder in due course would have the same standing, whereby the holder in due course will be saying that it's a better title which is free of all the defects. The next is with respect to rights of holder in due course with respect to inchoate instruments. Inchoate means incomplete instruments. So if there are instruments that are incomplete, those incomplete instruments can be completed by the person who's holder in due course. So it doesn't always have to be only be filled by a holder, the final presenter, or by the person who's made the check, but anybody who's a holder in due course can also fill up the instrument to make it more secure. Basically, that's the idea. The next is with respect to right in case of fictitious bills. I have mentioned on the check a holder's name which is called ABC Company Limited. Supposing ABC Company Limited doesn't even exist. So the person to whom I have actually given the check now endorses it in his own name, and then I present it to the bank. Now the bank can very well say that see, the check was made to ABC Limited and ABC has now endorsed it to you. So if this has been the case and ABC is not in existence as an entity, we will consider this as a fictitious bill, and which is why we are not going to pay on it. So the banker is basically an acceptor of the bill. As an acceptor of the bill, if you have not taken the payment, if you have not made the payment, uh, encashed that particular check, then it becomes a bit of a problem. because as a banker, the due diligence is something that has to be done by you. The next is with respect to right in case of instrument is obtained by unlawful means or by unlawful consideration. So section 58 technically debars you from uh, being in a position where the instrument is obtained by unlawful means or for unlawful consideration. So unlawful consideration or unlawful means could be in a way that says that uh, your the means of receiving that particular instrument has been incorrect. So in such cases, if it is opposed by law, so how would you deal with it, or how would you understand that particular section accordingly? So section 58 is where a holder in due course may get the right that if there is something which has been received by you, which was actually a resultant of a transaction of, say, gambling or anything which was against the law of the country, then in that case, you will be struck by this section, and therefore it would be a bit of a problem for you to get it encashed. But since you have received it for full value, you can claim it with respect to section 58. Payment in due course. This is what I was talking about. What exactly is a payment in due course? Payment in due course is a concept which has been spoken about under section 10. Section 10 of the NI Act says that all of these payments which are done without negligence and by taking proper due diligence and care, etc., that would be considered as a payment in due course under section 10. So if you have a payment in due course, then the drawee, which is the banker, and the paying banker is actually protected. So there can be two banks, like I said at the very outset, there can be a collecting banker, there can be a paying banker. The paying banker is the one which tries to save itself from all sorts of liabilities by proving that there has been a payment which has been done in due course. So if the payment is made in due course, then the drawee or the pay banker is protected. So clearly the drawee is the banker or the maker who has followed the instructions. But what are the things that you need to prove? Primarily three things. First, that the payment should be made in accordance with the apparent tenor of the instrument. So intention of the parties needs to be visible, and you can't have post-dated checks paid before presented before the date of its maturity. So that has to be a payment in due course, because today is the 16th of November. Supposing if there was a check that I received for 18th of November, clearly, even if it is, say, 1 day away or 2 days away, the banker cannot pay me upfront today itself and say that, fine, I'll pay you today. Because the payment in due course means that post-dated checks have to be paid on the same day of its maturity or until the expiry of that particular check, which is around near about 3 months. The next is with respect to the payment, which should be done in good faith and without any negligence. So a banker will not be liable if the banker has, say, said that I will not engage in fraudulent activities, or say the second is with respect to without any doubt as to the validity of the title of the payee, or the third is with respect to making proper inquiries, or you check the regularity of endorsements or confirm the material alterations. So there's a presumption as to the order of endorsements. So if A has made a check to B, so B will now endorse it to C will now endorse it to D will now endorse it to E, and so on and so forth. So in such cases, all of these, what do you say, endorsements is something which is regular, because B has endorsed it to C, C has endorsed it to D, and this is a sequence of endorsements. So it doesn't, so if the last person to be endorsed that instrument having been endorsed to, if it is Mr. E, and say still Mr. D has actually come to get the check and cashed, clearly the banker has to uh, uh, refuse the payment, because this is not a regular, this is not the holder according to the presumption of the order of the regularity of endorsements on that instrument. So this is something which has to be kept in mind. Material alterations you confirm from the maker itself. It may so happen the maker doesn't even know that the check is lost. And say supposing the check has been lost, say in the Mandi system or wherever, and if there has been an alteration with respect to the amount, so the maker wanted to make himself liable for 100 rupees, but somebody has clearly cut that off and written 1000 rupees, or say they've added one more zero to it by materially altering the figures as well as the amount, etc. So in such cases, if as a banker you still have not made a call to the maker, because there is a very reasonable suspicion on the part of the banker that should have arisen, because there has been an overwriting or some sort of a material alteration to that effect, then in that case you will be liable as a banker. The next is with respect to proper inquiries, and with respect to without any doubt as to the validity of the title of the payee, which shouldn't be fraudulent, and the title of the payee has to be very succinct. The title of the payee has to be very valid. And finally, it is about the third point, which is payment is to be made to person in possession of instrument. If drawer countermands payment, then holder doesn't get paid. If as a person who has made the check, if I don't uh, want the check to be paid, maybe for reasons that I think the check has landed onto a very unscrupulous person's hands, or say if I know that the check has been lost, or say if I know that uh, I may not have the amount of money in my bank account for the check to be encashed. So I may want to save myself from the troubles or the humiliations of check bouncing, etc. So in such cases, as a maker of the check, I can very well say that I want to stop the payment. So this is countermanding of payment. And once the countermanding of payment has happened, the idea is with respect to the fact that the banker is not now supposed to make any payments on it. Because I have instructed the banker to make the payment on the check, but clearly, in addition to it, I'm making another instruction to the banker not to make any payments on it. And this instruction is after my instruction of making the check. So in such cases, the banker has to honor the second instruction over the first, because it comes from the maker itself, the account holder, and the customer as such. And the customer's intentions are to be, what do you say, are to be fulfilled. So either you get your account blocked or frozen, etc., and say that the amount of money should be paid on this particular, maybe this one particular check number you can give to the banker and say that this particular check shouldn't be encashed, or you can just say blanketly any check which comes for encashment to the bank should not be encashed. Now these are the concepts with respect to payment in due course. The next is with respect to what exactly are endorsements. Endorsements is that concept whereby we are talking about how to propagate negotiability of a certain instrument. So when we are talking about negotiability of an instrument, it is only through the fact that you can do it with respect to uh, uh, a certain negotiable instrument, how do you how do you uh, ensure that this sort of what do you say, this sort of negotiation is carried forward? So negotiability is a very intrinsic concept which you'll have to consider. One second. Yeah. So endorsements are something that are something that propagate negotiation. Negotiation of an instrument. Yes, and that needs to be taken care of under the negotiable instruments as to how it is supposed to be done. So by delivery is under section 47. By endorsement and delivery, that's under section 48. So endorsement consists of signature of the maker or the drawer of the NI of the negotiable instrument or any other holder thereof. So the fact is, with respect to endorsements, section 15 is what has been spoken about under what endorsements are. So what are the legal provisions of an endorsement? The legal provisions basically deal with section 50, section 51, section 60, 56, 118, and 57. Section 118 is the presumption of endorsements with respect to the order of endorsements that I was talking about. That is something that has been spoken about under section 118. Remaining all these sections, effect of endorsements. The moment an endorsement has been done, the effect is basically that the new holder, the person who comes to hold that instrument, will now have all the benefits. The endorsee will now have all the benefits of that of a holder. He can very well go and encash the check in his own name once the maturity has arrived. And the fact that the check can now be encashed in his own name, and he'll get the rights of bills, etc. Or he can get the duplicate of it, and so on and so forth, basically. So, section 51 talks about who may endorse. Clearly, the person before you, the holder in due course, or the holder is supposed to give you that particular endorsement, no other person, not the maker, nobody. The next is with respect to time. When do you think it can be endorsed? So, you clearly can't endorse it once the check has been presented, or the check has matured and the presentment or the encashment of the check has been done. So you can't endorse it any further. So this endorsement is supposed to be done before the maturity of that instrument or before the check has been presented for encashment. The next is with respect. This is one of the most disputed sections actually, because lot many practical based questions actually come from here. Dishonor of NI. Now, we are just not talking about dishonor of checks. Dishonor of checks can happen for two reasons. One is non-acceptance, and the other one is regarding insufficiency of balance, insufficiency of amount in the account. So, the fact is, whenever we are talking about dishonor of checks, we are talking about non-acceptance as a bill of exchange or non-payment of that particular check, promissory notes or checks, dishonor by non-acceptance, which is under section 91, and dishonor by non-payment, which is under section 92. Section 138 of the Negotiable Instrument Act talks about the fact that it talks about the dishonor of checks. Now, even though this entire NI Act as such is a civil law, Section 138 has a criminal sanction that is attached to it. So whenever we are talking about Section 138, how is it actually taken forward? So every time that a check bounces, you're supposed to make the what do you say? You're supposed to make a legal notice. You're supposed to send a legal notice within a certain time frame and claim for the payment. Once the payment has been made, that's where it ends. But if the payment has not been made, then here is a problem where you go and institute a suit. And then it is heard by the appropriate metropolitan magistrate or the CJM, whoever is in the locality, based on pecuniary jurisdiction. Based on the roster system, one will be given. And finally, this would then go to the person which is in uh, the person who has made the particular uh, initiated the suit, has made the petition, is then called. Now, prima facie, you as the petitioner will have to prove your case as to the fact that you have in fact made the payment. Sorry, you are the one who requires the payment in a very good faith belief. The check was received by you. You were the particular holder who was entitled to the amount. You were a bona fide holder of that particular check. You received it for a full consideration of debt, etc., and not through gambling or any other means which is prohibited by law, so on and so forth. So this entire concept of dishonor by non-accept this section 138 as such, this technically presumes in the sense that it has to be proven that the person who's coming to claim for the money has come with clean hands and is the one who has actually in good faith been duped. Now, clearly, it's a criminal sanction because it tends to impede commercial transactions across the economy, which is extremely important for a country's machinery to run. So, if on a good faith belief, if you perform some services and if a check has been given to you, which doesn't get encashed for whatever reasons, it will be an immense amount of problem for the persons who actually need the payment. And thereby, this whole sanctity of good faith and belief on the whole mechanism of uh, the in the banking sector with respect to negotiable instruments will actually be dwindled. So which is why this concept section under section 138 etc has to be seen with respect to how the uh, uh, concept is taken forward. So criminal liability or unscrupulous drawers of checks towards discharge of debt or liability at as a whole or part, etc. So this entire concept is under section 138. And finally, we come to the ingredients. Section 138 to section 142. All of these sections technically talk about where the case can be instituted, territorial jurisdiction of which court will be there, whether do you lodge a complaint with the place, the court where institute a case where in a court in the area where the check has bounced or where the check was made or where the banker of the person who has tried to encash the check belongs to. So there are multiple variables to it as to where exactly can the case be initiated, can the suit be filed. Secondly, once a suit has been filed, what happens after that? With respect to suit, with respect to what do you say? How many, how much amount of money can be claimed? If there's any mean profit that can be claimed, what are the ingredients that you need to prove before you take the decision? with respect to presentment, which has to be done within a valid period, that dishonor, if it has been done because of insufficiency of funds. Now, if you plead not guilty, then clearly there will be a trial and then it might result in acquittal or in conviction, depending on whatever the sentence of the court is, on perusal of evidence, etc., preliminary evidence. But before that, you'll have to take an anticipatory bail. There has to be a summons issued. There will be a summons issued against you, etc. And all of these procedures would take place because the check that you mentioned, that the check that you've written has actually bounced because of insufficiency of funds. And the reason why the acceptance had not been done by the banker can also attract certain liabilities if the maker of the check is very clear as to the fact that he made the check in good faith and it was his account who which actually had sufficient funds. It was only the malified intent of the banker who refused the payment or the acceptor of the bill who actually refused to honor the particular check. And finally, we talk about when can a banker dishonor. So clearly, these are the reasons why a banker can dishonor. But if these are the situations, if there arises another situation which doesn't fall under these 4 points, clearly the banker would be liable. So if there is a drawer, checks have to be cleared within a certain period of time, which is the banking hours. I can't wake up a banker at 12 o'clock in midnight and say that I want the check to be encashed. Say very discreetly, I have found out that there is a particular man who has died. And clearly, the checks will now not be encashed out of his account because the account doesn't belong to him anymore because he's deceased, since deceased. So, in such cases, before the news spreads to the bank the next day morning, in the night, I wake up the bank manager and I said that I need the cash to be encashed, the check to be encashed. So, clearly, if the banker has tried to open banking business outside of the banking hours, and if the banker has tried to encash my check, so this would amount to connivance, and then the banker can be held liable. So the payment has to be done in due course, which entails everything. The fact that you are supposed to even be careful about the fact that there is a drawer's death, or there was an insanity or insolvency of the customer who has actually made the check, or whose signature has been used on the check, or the signature on the check is actually forged, or maybe the company which has given you the check, whose directors who have been authorized by the company have actually written that particular check, that company itself is in liquidation, or if the payment has been countermanded by the drawer. So as a maker of the check, if you say that I'm stopping all payments and if I'm countermanding the payments, in such cases, all of these could be grounds for non-acceptance of, which is not necessarily something that would deal with insufficiency of funds. So insufficiency of funds will be a very big reasons for dishonor of the check. But barring that, also there can be these 4 reasons where a banker can dishonor, and that would be very valid. That would be very a very legitimate ground for dishonor. Uh, is Rehan sir here?
Yes, ma'am. Yes, ma'am.
Sir, could you please write down the questions if there are
There
any?
is no question from student
Because
side.
I can't see. It would be very legitimate ground for dishonor.
No question from student side, madam.
Uh, is Rehan sir here? Okay, okay.
Yes, ma'am. Am I
So
audible?
I'll just wrap up with a bit on garnishee order. The garnishee order basically is where the banker has got an information from the court saying that this particular amount of money from belonging to this account will not be given to the creditor of that particular bank, in the sense that if I deposit the money in the bank, I'm the creditor, the banker is my debtor. So the banker will be stopped from giving me any money out of my own account, because the amount of money which is in my bank will now be attached for the purposes of my creditor. So if I owed a certain amount of money and the person has filed a suit against me because the debts are still pending, outstanding, then in such cases, the court order can very well affix my account, not freeze it, but attach my account for the purposes of encashment or dissolution of the debt of that other person who has filed the case. So the banker becomes the garnishee. The order is something that the banker has to fulfill with respect to the amount of money that needs to get that will be now frozen for the purposes of the debtor, and the fact that it has to be done in two processes. One is your order nisi, the other one is your order absolute, where the first order nisi, the court asks if there's any objection that a banker has for not freezing the accounts or attaching the accounts, because a banker may also be a creditor in the sense that, say, a loan amount is being deducted from that particular account. So the banker clearly has a charge over that particular account even before anybody else can. So that order nisi will determine, and during this order nisi, if there's no objection, the banker is supposed to let the customer know that no more is it going to honor the instruments, the checks, etc., which will be given to him. And finally, order absolute is where the final attachment of the account happens. So, yeah. If there are no questions, if there's no objection, the banker is supposed to let the customer know that no more is it going to honor the instruments, the checks, etc., which will be given to it.
Yes, ma'am.
Finally, order absolute is where the final attachment of the account happens. So, yeah. If there are no questions,